Executive Producer Eric here. We're going to take a step back and focus on the nuts and bolts of the legal process, because we know for our audience who are thinking about filing a claim that this process could seem daunting. For those who may be new to legal jargon or who have heard conflicting information about what's involved in working with a legal team, this episode is for you. Our co-host Tim has spent decades representing survivors of abuse, so he's going to walk us through some legal jargon, myths, and facts from how claims are filed to what survivors can expect at each step, and in the process, hopefully debunk some of the most common misconceptions. Whether you're considering taking action yourself or just want to better understand the system, we hope this conversation can provide some confidence and some clarity.
Well, this is going to be shocking because you'll be talking to one of us directly. And I've learned from experience that that is actually the most difficult hurdle our clients have to clear first. I've had so many clients say, I picked up the phone and called you, but then I had to put it down. Or I started to call and then no, I put it off. And this is being trapped in that fear. That's a huge first step, and we respect that. We don't need to know the horrible details of what were done to you. Nobody's going to ask embarrassing, intrusive questions. We don't need to know. We need to have a general understanding of what happened to you, when it happened to you, where it happened to you, but nobody is going to cross-examine you and force you to relive in vivid detail every terrifying second of your abuse experiences. That's not what this process is about. It's a process. You've come forward on your time when you were ready, and if you've called us, you're probably ready, and we're not going to push you. And we'll take it at your pace. And if you're emotional, that's normal. That's okay. We can take our time with this. You can take your time with it. There is, unfortunately, misinformation that people read on social media, and I'd like to address some of these inaccuracies. One is this idea that if you come forward and achieve a settlement with the church, that you'll have to sign some kind of confidentiality agreement that will prohibit you from ever talking about your case or anything of that nature. We don't sign those agreements. I wouldn't represent or take on a case if that was a condition. You will not have to sign away your right to tell your story to anybody else. If you want to write a book, if you want to go on a podcast, you're free to do that. It's your story, it's your life, and nobody's going to silence you any longer about it. Some people have the opposite concern, which is if they come forward, it's going to go public, that people are going to find out. But we have handled hundreds and hundreds of cases. Very, very few ever end up going through a court process. The overwhelming majority are handled privately, confidentially. Very few cases go to court. Is a different set of rules that apply. But that's a big decision to make, and nobody's going to push you to make that decision, and they shouldn't. It's a collaborative process. We collaborate. Too often lawyers don't listen to the most important person in their case, which is their own client. And I've been guilty of that in my career. I've come to learn that we are here to obtain accountability and justice for the client, but only the client knows what that means to them. It's not the same for every client. And you have to, as a lawyer, figure out what it is that they really want. And sometimes the clients don't know themselves exactly what they want because they don't know what their options are or what the possibilities are. So from the outset, it's a process of learning. The lawyers learn, the client learns, we learn together, and eventually we come to a point where we go, okay, I think we've got a plan here, and then we launch it. That has been a consequence of doing these cases against the LDS Church for nearly 4 decades. I think that is what separates us from other lawyers who purport to be able to effectively represent clients in claims against the Mormon Church. They just don't have the experience, the knowledge, or the understanding or the sensitivity to appreciate the unique experience of being a child sexual abuse survivor in the Mormon Church context, and it is unique. It is different. If your case is going to go to court, it's only because that's what you want. These are general legal principles. I'm not giving legal advice because I'm not licensed to practice law in every state. But generally speaking, a claim is you believe that you have been legally wronged. It may be a landlord, it may be an insurance company that's obligated to repair your car, but they won't. And so, you pursue a claim against them. It's merely just a presentation, a notice to somebody that you believe owes you something, and you attempt to work it out. Lawsuits are generally the result of that process breaking down, not working, a disagreement, an inability to reach a mutual understanding and a compromise. But a lawsuit is a formal proceeding that begins with the filing in a court, and it's a claim typically prepared by a lawyer in a document that's called a complaint. Individuals that you believe wronged you are named as defendants. You're the plaintiff. You're the person that's bringing the claim. The defendant can be your abuser. It can be the institution that enabled the abuser. It can be other parties who were at fault or also responsible for the abuse that you suffered. It launches a process. Lawyers refer to it as litigation, which is essentially a period of time during which both sides get to request and obtain information about the case from either side. And that process goes on. Typically, the overwhelming number of those cases get resolved at some point in the process by way of a settlement. And so that's a lawsuit. A class action is something that refers to a very narrow sliver of cases, not sexual abuse. Almost no personal injury cases are ever a class action system. They apply to those rare circumstances where you got a uniform harm that occurs to a large number of people. For example, the telephone, AT&T or your wireless provider has overbilled 17 million customers, 16 cents a month for 5 years. Everybody got tagged with it, and it violated some law or it was an overcharge. Those are the kinds of cases that can be packaged together. Everybody was affected the same way. There's similarity, commonality, and it really is just an exercise in arithmetic. There seems to be some misunderstanding that cases that are being brought for child sexual abuse involving the Mormon Church are class actions. They're not. I'm not even aware of any, and there won't be. They don't fit under the definition of class actions. So that's just something that should be dispelled. You're not going to be lumped into a class with dozens or hundreds of other people. Your case is going to be handled individually because they're all different. They arise in different states, different laws apply, people's injuries are different, the circumstances under which the abuse occurred are different. So it's very difficult to put those into a class action. However, they can be aggregated. So I've handled cases where I'm representing multiple individuals who were abused by the same perpetrator in the same church over an extended period of time. Those cases, because they share many common facts, can be joined together in a single lawsuit. And that makes for a very powerful lawsuit. So 16 people, 12 people, 4 people all made this up. They don't know each other. They were separated sometimes by a generation in time, and yet they were abused by the same perpetrator who was allowed to abuse over an extended period of time. So there are those kinds of cases. It's not a class action. It's multiple plaintiffs that are joined into a single lawsuit. But generally speaking, we try and avoid lawsuits and litigation because if you can successfully satisfy what the client wants, that gives them a sense of closure and a feeling that they've held the defendant, in this case the Mormon Church, accountable. That's a success. that's winning. We have many cases where the abuser is dead. It doesn't matter legally unless you are pursuing your abuser alone and he's dead and there's no ability to obtain accountability because he is dead and no ability to obtain compensation. Again, maybe in years and decades past, victims were not believed. And I think that this fear is a residue of times past. The world has evolved. Abuse survivors are believed now. There have just been so many that have come forward, whether it's in the Catholic Church or the Me Too movement, or it used to be very difficult for prosecutors to obtain convictions beyond a reasonable doubt because juries just were reluctant to believe the testimony of a child or of an adult telling this account. But now they've come to understand how common this was, how widespread it was. And it's also something that common sense tells you that a survivor wouldn't come forward and subject themselves to this if it were untrue. It's just the opposite. It's difficult to get them to come forward and speak their truth than it is a situation where fakers come forward and tell made-up stories that never happened. In my experience, that is so rare as to be non-existent. Our clients discover when they come to us, we say, listen to us, trust us. You've come this far. If we accept your case, we can get it resolved with the church. So the reason we're able to say that with such confidence is we've been doing these cases for nearly 4 decades. The cases that we take, we are able to resolve because they are meritorious, they are righteous, and persuasive. We've come to understand that there's a way to reach the church. In such a way, we've been successful in getting virtually all of our cases resolved. The church teaches its members that it has a duty to make restitution that those it has wronged. Well, the church is demonstrating that that same rule applies to them, to it. I would say that gives us hope. One of the fears that people have is that they can't afford lawyers, and lawyers are expensive. We aren't those kinds of lawyers. We work on what's called a contingency fee basis. In other words, we work for you, and if we're successful in obtaining a settlement that you want to accept, then we are paid a percentage of your settlement, and that's how. If we're unsuccessful, if we obtain nothing, and we've spent our time and money advancing your case, we don't make any money. We don't get paid. So we have an incentive to work hard for you because if you're not successful, we're not successful. So it's a partnership.
We know the legal process can feel overwhelming, but you're not alone, and understanding your options is a powerful first step. If you have questions or need support, visit architectureofabuse.com for resources and ways to connect.
If you'd like to discuss a potential claim, you can contact me via my website, kosnoff.com.